hope I can live up to even half of that splendid introduction. It is a delight to participate in this Sibley lecture series established in honor of an outstanding citizen of the state of Georgia and of the nation. The title of my lecture, Inviting Judicial Activism, a Liberal or a Conservative Technique, might attract a smile from John A. Sibley. A feature story about that fine gentleman reports that people were puzzled by his stewardship of the Sibley Commission, a commission appointed at a turbulent time in 1960 to hold hearings on the future of public education in Georgia. John A. Sibley had solid conservative credentials acquired in his years of work as a lawyer and as a banker. Despite that, he was labeled in 1960 in some quarters a big liberal. Turning to the lecture topic, who knocks at the court's door? Is it a liberal or a conservative? At his confirmation hearing, several questions were put to Judge Frank M. Johnson, then of the Middle District of Alabama, and now gracing the 5th and soon to be the 11th Circuit bench. Judge Johnson was asked particularly about his very active role in the judiciary. He was invited to state his views on judicial policy making. Judge Johnson explained that judges do not initiate lawsuits. They have nothing to do with the creation of the case or controversy that forms the basis of a lawsuit. But once a case is filed, if it involves plaintiffs with standing, plaintiffs who state a justiciable controversy, a judge lacks the luxury to refuse to adjudicate, however unpopular the cause or the litigant, however complex the matter tended for decision. The judge does not have discretion to adjourn court or to instruct the parties to go away. Yes, Judge Johnson acknowledged important judicial decisions do form policy. That, however, is not a latter 20th century development. Policy making by judges goes back to Marbury against Madison in 1803, McCulloch against Maryland in 1819, Gibbons against Ogden in 1824, Dred Scott in 1857, Brown against Board of Education in 1954 follows in the same line. Brown made public policy for the nation, but it did so as the fallout of a bona fide case or controversy that the judiciary had no hand in creating. Judge Johnson concluded with a recent example, the well-known Alabama prison suit. After 6 days of plaintiff's evidence, the attorney for Alabama rose in open court and confessed that every prisoner incarcerated in the Alabama prison system was subjected to cruel and inhuman treatment within the meaning of the 8th Amendment. With that confession, Judge Johnson said, the task of the federal judge, at least the starting point, was inescapable. Relief was mandated. The only question remaining was the type of relief necessary to redress systemic violation of the Constitution. The legitimacy of court intervention was clear, but the competence of the court to shape and administer an appropriate remedy was a very large problem. the judiciary has been the forum of ultimate resort for individuals and organizations representing almost every position on the political spectrum. Civil rights groups have no monopoly in representing people who are discontent with legislative or executive action and seek the aid of the courts to set things right. Columbia Law School professor and court watcher Maurice Rosenberg, borrowing from Shakespeare, remarked that Americans nowadays troop to court with distresses, anxieties, and wounds they once regarded as the slings and arrows of outrageous fortune. But the phenomenon is not an entirely new departure. Before the midpoint of the 19th century, de Tocqueville commented, "There is hardly a political question in the United States which does not, sooner or later, turn into a judicial one. The spirit of the law, born within schools and courts, spreads little by little beyond them. It infiltrates through society right down to the lowest ranks." A few months ago, Carl McGowan, my sage and kind colleague and now Chief Judge of the D.C. Circuit, presented a Sibley lecture. He commented on a particularly interesting class of new plaintiffs who have pressed for judicial activism. The new plaintiffs Judge McGowan spoke of are legislators themselves, among them many celebrated members of the House and Senate, names regularly encountered in the daily press, persons known for their leadership qualities. Often the dispute of the new plaintiffs is less clearly with the executive than it is with the views, or at least with the inaction, of their legislative colleagues. United States engagement in Indochina brought appeals to the courts from several prominent legislators. Those legislator litigants were identified as liberals. More recently, the standard bearers urging bold judicial action have carried a conservative banner. Legislators so identified have asked the courts to declare unconstitutional use of the treaty process to return the Canal Zone to Panama. Perhaps most widely publicized among recent legislators as plaintiffs' cases, several conservative members of Congress joined in an attempt to block the president from terminating, without a bright green congressional light, the United States-Taiwan Mutual Defense Treaty. The judiciary is understandably reluctant, as Judge McGowan said, to be regarded as a higher chamber where a legislator who has failed to persuade his or her colleagues can always renew the battle. Decisions dismissing the claims of liberal and conservative legislators alike on standing or political question grounds are not a model of sharp and clear reasoning. Judge McGowan, in his lecture here, pointed to a principled, appropriately restrained approach for the courts in such cases. On equitable grounds, he suggested, there should be no intrusion into the affairs of a co-equal branch on the invitation of a legislator when collective action by Congress would afford the individual plaintiffs significant relief. I turn now from the legislator as litigator to others who pursue the public and their own interest. Cases involving participation in the political process present a spectacular assortment of plaintiffs. In Williams against Rhodes, the American Independent Party, which supported Alabama Governor George Wallace's bid for the presidency, lined up with the Socialist Labor Party. Both attacked obstacles Ohio placed in the path of third-party candidates seeking ballot access. An all-American team took on the Federal Election Campaign Act in Buckley against Vallejo. The lineup included, among others, former Senator James L. Buckley, then a New York conservative, former Senator Eugene McCarthy, a liberal candidate for president, the Conservative Party of the state of New York, the Mississippi Republican Party, the Libertarian Party, the New York Civil Liberties Union, and the American Conservative Union. Among the political parties mounting a recent successful challenge to mailing rates that favored the two major parties were the Free Libertarian Party, the Socialist Party of America, and the Conservative Party of the state of New York. Republicans, Democrats, and the state of Georgia have attempted to draw the courts into the internal politics of the national parties by challenging convention delegate allocation formulas. A turbulent political question in the past several years, whether we should have an Equal Rights Amendment, has entailed several forays in court. Amendment supporters have attempted to block a Nevada non-binding referendum on the ERA by resort to litigation. Proponents of the ERA also sought to defeat by judicial decree an Illinois requirement that proposed amendments to the federal Constitution be approved by a 3/5 majority of the state legislature. On the other side, amendment opponents initiated litigation in the state of Washington and thereafter in federal court in Idaho, seeking declarations that Congress acted unconstitutionally in extending the deadline for ratification of the ERA and maintaining that purported rescissions of ratification count. The state of Missouri challenged under the Sherman Act and state antitrust law a convention boycott led by the National Organization for Women and directed at states that had not ratified the ERA. In 1971, then private practitioner Lewis F. Powell, Jr. prepared a confidential memorandum for the United States Chamber of Commerce. In it, he said, "The judiciary may be the most important instrument for social, economic, and political change." He advised the business community to adopt the astute ways of activist liberals, particularly their tactics in exploiting judicial action. Since that time, several public interest legal foundations have been established to represent conservative or business interests. Among these are the Mountain States Legal Foundation and the Pacific Legal Foundation, both regular challengers in court, often in opposition to consumer or environmental groups. The Pacific Legal Foundation, for example, has challenged a Department of Transportation rule requiring car manufacturers to install passive restraints in all automobiles marketed after September 1st, 1983. It joined with a group of California legislators in an effort to stop the Environmental Protection Agency from penalizing California for failing to enact anti-pollution laws that met EPA's stringent demands. And it sided with other plaintiffs against California in challenging restrictions California had imposed on the construction of nuclear power plants. Pursuing a government in the sunshine position usually associated with liberals, the Pacific Legal Foundation successfully sought a court order opening to the public formally closed Council on Environmental Quality meetings. The Pacific Legal Foundation and the Mountain States Legal Foundation were aligned with the American Civil Liberties Union as amici in urging successfully that warrantless searches of business premises authorized by the Occupational Safety and Health Act violated the Fourth Amendment. Business interests have nurtured one of the newest growths in the First Amendment area. They have argued with a considerable degree of success for judicial protection of commercial messages against legislative limitation. A leading commercial speech case, Virginia State Board of Pharmacy against Virginia Citizens Consumer Council, was brought on behalf of consumers, but it was not the first entry. The first court assault on the legislation there involved a Virginia statute prohibiting pharmacists from advertising the price of prescription drugs was brought by a drug retailing company. A realtor successfully attacked in court the ordinance of a New Jersey town prohibiting the posting of for sale signs, a measure that the town sought to justify as a check against white flight. Banks and business corporations in Boston joined forces to achieve judicial invalidation of a Massachusetts statute forbidding those enterprises from spending money to influence public referenda on questions unrelated to their business interests. Most recently, utility companies mounted successful challenges to energy conservation-minded orders of the New York Public Service Commission, orders that directed the utilities to cease promotional activities, promotional advertising, and desist from discussing controversial public policy issues in bill inserts. It may be a fair conclusion that in the American legal system, calls for judicial intervention for activist review of legislative and executive decisions depend less on the challenge's liberal or conservative credentials or ideology, and more on the pragmatic question, whose ox is being gored? A remark made by Fifth Circuit Judge Irving L. Goldberg in another context indicates the position of courts invited by litigants to resolve difficult cases presenting vibrant public policy issues. If the threshold requirements are met, Judge Goldberg said, the judicial firefighters must respond to all calls. Clearer standards, principles, and guidelines from the legislature would facilitate the work of the judicial firefighters. A few years ago, Judge McGowan commented on the load Congress places on the courts when it delegates broad authority to administrators in terms highly general or ambiguous. Judge McGowan sensed in some legislation of this genre a desire on the part of members of Congress to escape from having to stand up and be counted. He counseled a Congress genuinely concerned about delegated power has one effective contribution that it and only it can make: the identification and definition as precisely as possible of that power and of the standards to be observed in its exercise. Justice William H. Rehnquist recently expressed the frustration judges feel when confronted with the murky, buck-passing brand of legislation that casts unwanted construction and application burdens on the courts. Speaking of a provision of the Clean Air Act, he remarked, "The effort to determine congressional intent here might better be entrusted to a detective than to a judge." Similar refrains are regularly sounded in the court on which I serve. As Judge Edward A. Tam said of a recent case, clouded by hazy congressional action, our search for an explicit legislative directive leaves us groping in the dark. Courts are vulnerable to criticism for overreaching when Congress is too busy or too divided politically to speak with precision. Echo Corporation against the Environmental Protection Agency typifies situations in which Congress might have supplied an explicit directive, thus sparing judges the job of divining legislative intent in a misty atmosphere. Section 211 of the Clean Air Act authorized the administrator of the EPA to regulate fuel additives if any emission will endanger public health. Congress did not say in the statute, nor did the legislative history sharply indicate, whether will endanger meant that the administrator should act only on demonstrated harm, or, short of that, on a significant risk of harm. The administrator used the latter standard in establishing a schedule for the reduction of lead in gasoline, and the court upheld the administrator's interpretation. Similar ambiguity infected Congressional amendment of the Food Stamp Act in 1971. The House apparently favored a lower monthly allotment per family, but the Senate adopted the most generous plan that the Department of Agriculture had put forward. At conference, the senators suggested splitting the difference between the $106 amount under the least generous plan and the $134 the Senate favored. That concrete proposal to allot $120 per month per family of 4 was not accepted, and the act was left with only the less than crystal clear instruction that food stamp recipients received the opportunity to obtain a nutritionally adequate diet. What did the opportunity to obtain a nutritionally adequate diet phrase mean? According to the House conferees, it meant exactly what it said, nothing more and nothing less. As Judge McGowan commented, Congress had before it the information necessary to make an informed policy choice as to the amount of money the government should spend on upgrading the diets of the nation's low-income citizens. But it postponed that difficult political decision, leaving it for arguably less qualified, if only because they are not elected, administrators to make and judges to review. In the recent Occupational Safety and Health Act benzene case, Supreme Court Justices Powell and Rehnquist signaled to Congress their distress with legislation skipping over or opaquely addressing hard issues. Justice Rehnquist made a strong plea for revival of the impermissible delegation doctrine. He said, Congress, the governmental body best suited and most obligated to make the choice confronting us, has improperly delegated that choice to the Secretary of Labor and derivatively to this court. Another controversy heard by the D.C. Circuit en banc, Jordan against Department of Justice, seems an appropriate final entry in this very random sampling. Exemption 2 of the Freedom of Information Act exempts from disclosure matters related solely to the internal personnel rules and practices of any agency. As Judge Malcolm R. Wilkie has pointed out, the House and Senate reports on the Freedom of Information Act offer diametrically opposite explanations of the exemption's meaning. The Senate report, Judge Wilkie remarked, covers all the documents nobody would want. Trivial housekeeping items such as rules on employees' use of parking facilities and lunch hour regulations. By contrast, the House report describes Exemption 2 as covering operating rules, guidelines, and manuals of procedure for government investigators or examiners, matters in which diverse members of the public have a substantial interest. The D.C. Circuit, dividing 7-2, followed the Senate's interpretation. The court's resolution of that controversy, incidentally, was triggered by the demand of a law student for 2 documents concerning the exercise of prosecutorial discretion by the U.S. Attorney in Washington, D.C. Lately, federal prisoners have exhibited perhaps a less academic interest in such documents. Of course, there are situations in which Congress must paint with broad brushstrokes. The complex, arcane nature of scientific or technological factors, the unforeseeability of future developments, may prevent even the most diligent legislator from articulating precise criteria to guide administrative action. But when alternative policy choices are entirely feasible for Congress to make, elected representatives should make those choices and state them plainly. Legislators in such cases should not transfer responsibility for decision-making to administrators and judges. Legislative activism would substantially aid both judicial and administrative restraint. During Senator Kennedy's term as chairman of the Senate Committee on the Judiciary, the Republican members employed a minority questionnaire. The questionnaire expressed concern about the role of the federal judiciary within the federal government and within society generally. The then minority inquired particularly what nominees for federal judgeships thought of criticism directed at the federal judiciary for usurping many of the prerogatives of the legislative branch of the federal and state governments. A candid answer, I believe, would note, as many nominees did, that the need for interventionist decisions, for example, Judge Johnson's rulings in the Alabama prison case, would be reduced significantly if elected officials shouldered their full responsibility for activist decision-making. A theme different from the one suggested in the minority questionnaire achieved some popularity in the same time period. There has been talk, even among one-time critics of an imperial judiciary, of restoring the supremacy of the courts, of impelling the judiciary to reclaim its responsibility under our system of government, that responsibility interpreting the law. Statements of this character have been made by supporters of a proposal known as the Bumpers Amendment, a provision that would eliminate the presumption of validity of certain administrative agency action when challenged in court. Specifically, the Bumpers Amendment would amend the Administrative Procedure Act by requiring a court, when agency action is challenged as exceeding statutory authority, to determine whether the action is authorized expressly or, if the language of the statute is ambiguous, then by other evidence of ascertainable legislative intent. The Bumpers Amendment responds to congressional concerns about overregulation and desires for increased monitoring of agencies to stem a flood tide of legislative-type regulations. There may be widespread agreement that agencies should be held accountable to Congress, and through it, to the people, to a greater extent than they now are. But inviting more activist judicial review seems a questionable approach to the problem. The Bumpers Amendment appears to me an avoidance device, a proposal to assign to the courts responsibility Congress should assume in the form of closer oversight of agency output and, as I suggested a few moments ago, more precise standard setting in statutes delegating authority to agencies. The D.C. Circuit docket is heavy with challenges to agency action. Fair appraisal of the decisions of the D.C. Circuit and other federal courts does not lend large support to the proposition that the judiciary defers excessively to an agency's determination of the scope of its statutory authority. As Judge Tam explained in a recent decision, deference is the general rule in two settings. First, when special administrative expertise is genuinely implicated. Second, when Congress has acquiesced in an administrative determination brought to its attention. On the other hand, following the Supreme Court's lead, the D.C. Circuit reiterated a few months ago that courts are the final arbiters on issues of statutory construction and should not rubber stamp administrative decisions that misinterpret a federal statute. Substantial deference, the court said, is largely dependent on the quality of the agency determination, the thoroughness evident in the agency's consideration, the validity of its reasoning, and the consistency of the determination with earlier and later agency pronouncements. Judge McGowan, reflecting on his own performance and that of his colleagues, said of the bumpers approach, "I see nothing in the amendment that would stop me or any other judge from going about our interpretive job in the way we always have." If courts do not defer uncritically to agency decisions, then the bumpers amendment is based on a doubtful premise. The proposal might be regarded as innocuous, as harmless error, if it entailed no serious risk of adverse consequences. But several such consequences have been suggested. Judge McGowan alluded to the danger that Congress and the public might be lulled into overestimating the extent to which the judicial review can be relied upon as a check against an agency's misuse of broadly delegated legislative power. Professor Ronald Levine of Washington University, in a comprehensive analysis of the bumpers amendment, points to the litigation promotion feature of the proposal, the prospect that agencies would resort to decisional processes, adjudication, and informal guidelines that are more costly and less efficient or less open to public comment than rulemaking, and the likelihood of delay as agencies build ever more ponderous records in an effort to stave off judicial remands. In sum, Senator Bumpers has identified an area in which more activism is appropriate, but the need, I believe, is not for legislatively mandated heightened judicial scrutiny. It is again for legislative activism to chart and keep administrators on course with their statutory authority. To conclude these reflections on the situation of judicial firefighters, particularly those on the federal bench, I would like to share with you some thoughts on a development I regard with apprehension and with which I have had a personal encounter. In June 1980, an organization called United Families of America addressed testimony to the Senate Committee on the Judiciary, questioning my nomination. United Families of America expressed grave concern about the attitude of federal judges on important issues of social policy. The organization proposed that the committee ask me and every other nominee to the federal bench a series of questions. The questions purportedly would test the nominee's balance and reveal any bias toward judicial activism, which could cause tremendous damage to the American legal system. Among the questions the organization wished to pose for my answers: can Congress limit the jurisdiction of federal courts in, say, school busing cases? Do parents have any rights with respect to abortions performed on their minor children? For example, do they have the right to be informed that an abortion is to be performed? Present law and practice of the armed forces of the United States exempt women from combat positions. Could that exemption withstand a constitutional challenge? Why should a state not be allowed to rescind its ratification of the proposed Equal Rights Amendment up until the time when the requisite 3/4 of the states have ratified? United Families of America anticipated that some nominees to the federal bench would resist answering questions such as these because they relate to matters that might be aired before the judiciary in a live case or controversy. Of course they may, United Families continued. That is exactly why these questions should be asked and why answers should be insisted upon. The federal bench in the United States enjoys, and I believe generally merits, a place high in public esteem. In large part, that high esteem reflects the independence and integrity of the people who serve on the federal bench. In my view, the suggested attitude test for federal judicial nominees is a dreadful idea, one capable of doing tremendous damage to the American legal system. I doubt that individuals with the talent, self-discipline, skepticism, and independent spirit that federal judges should have would willingly expose themselves to the kind of screening United Families of America proposed. The wrong-headedness of the proposal is indicated succinctly in a statement made by Justice Rehnquist. He said he would distinguish sharply between a public statement made prior to nomination for the bench, on the one hand, and a public statement made by a nominee to the bench, for the latter to express any but the most general observations about the law would suggest that in order to obtain favorable consideration of his nomination, he deliberately was announcing in advance, without benefit of judicial oath, briefs, or argument, how he would decide a particular question that might come before him as a judge. Moreover, it is questionable whether one can accurately forecast judicial performance from statements made as an advocate or as a public-spirited citizen. Justice Felix Frankfurter, known for his activism as a lawyer and law professor and for his restraint as a judge, believed there is a good deal of shallow talk that the judicial robe does not change the man, and today we would say, or woman, within it. It does. The fact is that on the whole, judges do lay aside private views in discharging their judicial functions. This is achieved through training, professional habits, self-discipline, and that fortunate alchemy by which men or women are loyal to the obligation with which they are entrusted. Further, if a nominee were prepared to give answers that United Families of America would regard as right, many would suspect that the responses evidence lack of qualification, or at least lack of sound judgment, not balance or lack of bias. To quote Justice Rehnquist again, a judge steps out of the proper judicial role most conspicuously, most dangerously, when he or she flinches from a decision that is legally right because the decision is not the one the home crowd wants. 65 years ago, a nominee to the Supreme Court encountered determined opposition, in part because he had been an activist on the important issues of social policy of his day. A statement made by Senator Thomas J. Walsh of Montana helped turn the tide. Senator Walsh said of the nominee, "He has been an iconoclast. He has written about and expressed views on social justice. It is easy for a brilliant lawyer so to conduct himself as to escape calumny. All he needs to do is to drift with the tide. He will have no enemies or detractors, or at least none that he need heed. Discouragements enough beset the ambitious youth who strives to render some real public service. I do not care to warn him to abandon the hope of reaching the summit of his profession by that route." Senator Walsh concluded his remarks, "My vote is for the confirmation of the nomination of Louis D. Brandeis for Associate Justice of the Supreme Court." I think most lawyers would agree that it would be a tragic loss if activism of the kind in which Justice Brandeis had been associated were ever to be regarded as rendering a person unfit for judicial appointment. The American Bar Association last summer stated with courage and clarity that association's views on attempts to politicize the judiciary by asking nominees as a precondition of their appointment to declare their opinion on such issues as abortion, handgun control, prayer in schools, or busing to achieve racial balance. The association's House of Delegates adopted a resolution prompted by the Republican Party's platform plank, a plank pledging to work for the appointment of judges at all levels of the judiciary who respect traditional family values and the sanctity of innocent family life. The plank was intended and understood by the press and the public to favor the appointment of judges who oppose abortion. Reaffirming the American Bar Association's support for an independent, nonpartisan judiciary, the House of Delegates declared its disapproval of any platform plank that deviated from selection of judges on the basis of merit by superimposing a test of the candidate's particular political or ideological philosophies. Explaining the House of Delegates resolution, ABA's president, William Reese Smith, Jr., said, "Attempts to politicize the judiciary lend legitimacy to the notion that federal judges make the law solely according to their own private viewpoints and prejudices, and without seeking to balance competing social interests according to established legal principles and precedents. That implication confounds the public's perception of the legal system and encourages disrespect of the vital role that judges play in our government." Mr. Smith ended his comment on a note of optimism. "I am confident," he said, "that despite the rhetoric of the campaign trail, the leaders of our country are committed to an independent, impartial judiciary." Most jurists, I believe, would respond to Mr. Smith's comment with a rousing amen. If you will bear with me just for a moment, I have reached the conclusion. When asked the question, "Are you a partisan of judicial activism or of judicial restraint?" will you be a liberal or a conservative on the bench? Lines from Gilbert and Sullivan's Iolanthe enter my mind. The scene shows Private Willis posted on night-long sentry duty before Westminster Hall. To while away the time, he speculates on why Great Britain's parliamentary system works as well as it does. Private Willis explains in song, when in that house MPs divide, they've got to leave their brains outside and vote just as their leaders tell them to. They can do this thanks to the providence that nature always does contrive, that every boy and every gal that's born into the world alive is either a little liberal or else a little conservative. Were this not the case, then there would be the prospect no man can face with equanimity a lot of dull MPs in close proximity, all thinking for themselves. But not empty minds, individuals willing to listen and to learn. They have been skeptical of party lines, and they have exhibited a readiness to re-examine their own premises, liberal or conservative, as thoroughly as those of others. Thank you.
Ginsburg for that most informative lecture. She's willing to respond to a few questions, so let's have one or two. Here we are, right here.
You spoke about the Bumpers Amendment, and I want to disclaim that I'm a member of the United Congress, but Senator Strom Thurmond has recently talked about trying to limit the scope of federal decision-making in the courts by Congress, by act of Congress. And I was wondering what your impression of that would have, what effect that would have on judicial activism in this country.
You'd have to give me a specific, a concrete proposal. The Bumpers Amendment, of course, would enlarge judicial scrutiny, not contract it.
It was in reference to limiting federal judicial action in the kind of issues that you were speaking of, abortion.
Well, we must take into account that our highest law is the Constitution, and any legislation that's passed has to be consistent with that. I have never been of the view that the Constitution is solely the province of the judiciary. I think every responsible member of Congress, before voting on a measure, has to make that determination. How does this measure up against our highest law? Is it constitutional? And suppose something that I didn't like, that I didn't favor, were being given this treatment. Would I think that that was constitutional? Any legislation that you would adopt for a principle that you support, you would have to be willing to hold that that measure would be equally constitutional if it were something that you did not personally support.
I have another question. I'd like to ask you to make a comment something that Bill Span's very interested in. About 2 years ago, he gave the Law Day speech here, and he talked about the proliferation of litigation and the logjam in our judicial system, both at the state and federal level. And we've heard from Maury Rosenberg and others about the great mass of litigation, cases that are being brought in the federal and state systems, and the workload of the Supreme Court. After a few months on the federal bench, do you have any ideas as to how to get the workload of the federal judicial system back in perspective of the proper balance?
Our Chief Justice has said that every time Congress passes a new statute, it should do a judicial impact statement. I don't think that's a joke. I think he meant it seriously, and I think seriously that it should be done. I gave a few examples, but there are many others that could be cited of Congress dealing with a problem in a highly ambiguous way, setting up an agency or giving an agency authority to make a determination and then having the courts review it. So I think a much more careful job at the congressional level would be one thing. There are experiments going on with taking cases out of the judicial system, but those go more to private controversies than the kind of public law controversy, administrative agency controversy that I concentrated on.
Any more questions? I guess you've answered. Oh, here's one back in the back.
Judge, I was wondering, considering the little hand slapping the D.C. Circuit got a few years ago from the Supreme Court about remanding cases to agencies with additional procedures not specified in the APA, have you felt that has forced judges to decide substantive questions that were originally supposed to have been put before the agencies who have expertise in them? And in your experience, have you found it difficult to deal with the questions regarding environmental regulations and other technical areas?
Well, those, of course, are difficult to deal with, and the review standard, whatever it is not going to make that job of acquainting yourself with some very difficult background. But the Vermont Yankee decision, I don't think it has had all that tremendous impact. For one thing, Congress itself has added in particular statutes procedural requirements that go beyond the APA. At the same time as the Vermont Yankee question was coming out, it went to additional hearing requirements, additional requirements on the procedure side. The courts had also developed an approach on the substantive side of taking a hard look at what the agencies were doing, not second-guessing them, but just making sure that they had, in fact, considered the relevant factors. And Vermont Yankee, I don't think, touches that. But that's what a court is equipped to do. A court is not equipped to decide these difficult technical questions, but it can make a judgment of whether the agency has first followed whatever procedure Congress has required, and then made a reasonable decision.
I guess what I'm asking you is, I think it was Judge Wright's opinion in Apple Corporation. He said that he felt that the standard of review was very limited, but he felt it necessary, from his perspective anyway, to review the facts very carefully. Does this put a judge in a very difficult position of having to become an expert in a field that, some of that stuff I know that I can't begin to understand, and apparently, I'm sure some judges have difficulty understanding it too.
Great difficulty. But you never, of course, not become an expert, but understand enough of it to be able to have a sense of whether the agency has considered the relevant factors and come to a fair determination. Other than that, if the court didn't do that, it would be simply rubber stamping the agency decision.
Professor Bruce asked a question.
Short of reviving the non-delegation doctrine, how do you propose to require Congress to make the hard choices it must make?
Court can't require that of Congress. I mean, we don't have a device of remanding to Congress. Court has to decide the case.
So it's a fond hope that Congress somehow will rise above what it's done in the past and will make hard choices resulting in clear legislation.
Well, I don't think that we will ever reach that great day, but that Congress can do better than it has up till now. I think undoubtedly that is possible.
Well, thank you again, Judge Ginsburg.